Welcome to the Fearless Floyd Show. We'll begin in 40 seconds. And this is what they're doing. And I tell everybody, how do you overcome the fraud and corruption in the courts when they're not even playing by their own rules or own laws?
Yeah.
Do we need to scrap the whole system and create a new judicial system?
Well, that's a great question, and I think we're going to find that out. I still believe in the system. I still believe it could work, but let's look at it like this: that every tyrant trains their followers to follow them, right?
Yeah.
That's why Saint Augustine of Assisi, he said that how incredibly like are all the tyrants, because they all act the same way, because one tyrant will teach another tyrant how to act. So if the Supreme Court of the United States is acting unconstitutionally, if they're following judge-made rulings, if they simply follow the flawed decision of the man that came before them, like any other weak, timid sheep, then that's what they're going to teach their followers to do. Every member of the judiciary is going to be taught to act consistent with their leadership. And the Supreme Court of the United States, just as I said, in 1884, the Supreme Court of the United States came out and said, states, you don't have to follow the Constitution. You don't have to follow the Fifth Amendment. It doesn't apply to you, states. You don't have to do what the Constitution requires you to do. And ever since 1884, that court has been under the belief that states don't have to do it. I mean, it's insane how many millions of people have been prosecuted since 1884 by way of information, non-indictment, despite the fact that the Constitution guarantees the right to the grand jury. And if we can, in a moment, let me come back and explain the purpose of the grand jury, because it's so important that people understand that. But my point is that all of these judges are all being taught to do things a certain way. That's why I'm not trying to fight any of these individual cases. Like, if I were to come out to Texas, there's hundreds of people that are asking me to come and help them with their case in Texas. And yeah, we could possibly win one or two, but the truth is that we got one fight we need to win. Because if we can make the leadership, we can make the leader obey the Constitution and turn them back from their unconstitutional acts, then by their judicial ruling, they will direct all of the judges across the country, all their followers, that they need to now follow something different. They need to add a different direction. Therefore, there's really one fight that we have to win, right? And that's against the Supreme Court of the United States. The truth is we couldn't fight this absence of the indictment by a grand jury within any other court, because it was the highest court in the land that introduced that fraud in 1884. Therefore, it's only the highest court in the land that can remove the fraud. Right? That's the truth. That none of these lower courts are going to say, well, we have to do it now, because the Supreme Court of the United States is the one that has to remove the fraud and correct their unconstitutional, illegal, completely biased and erroneous ruling that they made in 1884 by a court that was well known to be a science experiment at best, the Waite Court. But that just means that's the fight that we need to fight, and that's why. We only have to get in and be heard. And that's the real question is, are we going to be able to? Are we going to get this court to own up to what they did in 1884 and fix it, right? Because, this is a big deal. I mean, what are they going to do about more than 700,000 currently void judgments because they derive from a direct facial constitutional violation at the point of the arrest? What are they going to do about that? Those people are facially, unconstitutionally being held because their arrest was unconstitutional. Therefore, there is no judgment, because if the arrest is unconstitutional, everything comes from it must also be unconstitutional, completely void ab initio. We know this, right? This is a big deal, and it's a difficult thing. But my answer to that is that, first off, First off, yeah, this is a big deal. And you did the Lexington, Kentucky introduction there, and I kind of laid it out a little bit to them. That was the first time that I had actually used some very specific terms, and that was saying to them, listen, I know this is a big deal because when I go into a city council and I inform them that they are paying police to violate the Constitution of the United States and that in and of itself is a crime, which is what we're doing. I mean, when I go in and I tell them that those public officials, those city officers, officials, they got to decide: am I going to continue to pay people to violate the Constitution, and thus I'm now knowingly and willingly committing a treasonous act? Because if I provide notice and notify them that this is happening, and they fail to correct those unlawful acts, those unconstitutional acts, then they are now paying for those crimes to be committed. There's no longer, the benefit of negligence. It's now knowingly and willingly committing treason, and violating the Constitution, paying people to do so. But my point is that when I went into Lexington, Kentucky the other day, I said to them, listen, I know this is a tough decision. It's a tough decision. I get that, because you right now are going to have to decide: am I going to follow a judge-made ruling, or am I going to follow the Constitution of the United States of America? Constitution says you have to do this. Judge-made ruling says that you can do this. Which one are you going to decide to do? That's a tough decision. I get that, city of Lexington, city council members, but it's a decision that you're now going to have to make. And if you choose to not make the decision, just understand that is still a decision, and it's going to be the wrong decision, because if you continue to pay people to violate the Constitution of the United States after being made aware that you're doing it, then there's no longer the act of negligence, right? There's no longer an opportunity for you to say, I didn't know. You did know because we informed you. But one thing I point out there was that in abuse of discretion, according to the United States Circuit Court, right? If you guys want to know what an abuse of discretion is, that would be someone abusing the discretionary authority with which they're invested in law in order to bring about a desired outcome, right? But if you want to know what an abuse of discretion is, you would go to the United States Circuit Court Handbook. And it says that there is a two-part test to determine abuse of discretion. Two-part test. Forget the first part of the test. Let's just go to the second. Because the second part of the test says any erroneous view of the law is an automatic abuse of discretion. Any erroneous view of the law is an automatic abuse of discretion. So when I was there serving the city of Lexington, Kentucky, I pointed out the fact that if in your legal contemplation that a judge-made ruling is superior to the Constitution of the United States of America, that would be an obvious erroneous view of the law. Therefore, an automatic abuse of discretion will in fact occur if you continue to pay these public officials to do the things that they're doing in violation of the Constitution of the United States. Constitution is the supreme law of the land. If it says you have to do something, I don't give a shit what told you you don't have to do it. Whether it's a judge-made ruling from the highest court in the land, doesn't matter. Right? What matters is what the Constitution says. And if you don't follow it, then you are now knowingly and willingly committing crimes, and you're a member of a criminal conspiracy. And according to law, you can be held accountable all the way up to capital punishment. I mean, this is all very well known. So, we're not going to get the outcome that we want from the state judges. In fact, I'm going to tell you that I would say that the majority of the people that I'm running into, law enforcement, the judges themselves, the attorneys, none of them ever even realized this. It never even occurred to them. These attorneys were just taught by law school that, you don't have to do it, and they never questioned it. It never even occurred to them. Constitution says this, why aren't we doing it? It never. In fact, I met with an appellate attorney, right, who has been an appellate attorney for 30 years. Her whole job was to identify constitutional violations within judgments, and she's been doing it for 30 years. When I told her about this grand jury indictment issue, she turned white and said, "Oh my God, you're right." 30 years, it had never even occurred to her that this could be a breach of constitutional violation. Never even occurred to her.
Wow.
So we have to win against the Supreme Court of the United States. And the only way we can do that is by making enough noise, bringing enough attention to this issue, informing enough people about the issue so that they will go out and help spread this. And that's what will push us into the court. This Supreme Court of the United States is going to ignore this as long as they possibly can, because they don't want to admit the truth. but we're not going to allow that to last too much longer, right? This is what I've dedicated my life now to, and I hope that will be done sooner rather than later. But that's going to depend upon how many people are going to get behind this, help me spread this, and share this information. Because the truth is that there will come a point in time when the Supreme Court of the United States will no longer be able to ignore this issue, and they'll have to hear it. And when they do, we win, because the Constitution of the United States must be followed. That Supreme Court knows it. And so, one of the things that I have, the argument that I have for the Supreme Court of the United States, is that the only thing that gives the Supreme Court its authority to do anything, to even be a court, is Article 3. Article 3 of the Constitution of the United States of America is the only thing that gives that court its authority to even be a court. So if that court is unwilling to step up and defend Article 3 and preserve the Constitution of the United States of America, that court can just turn off its lights. Those justices can go home because they have no power anymore. They will have voted themselves out of all power, and there is no need for a Supreme Court anymore, because if that court can't preserve the Constitution of the United States of America, there is no America anymore. Go home. No. Including all of you legislators, United States congressmen, United States senators. If you can't preserve the Constitution and say our delegated duty is to amend it, no one else can amend it because we initiate that. If they can't step up and defend the Constitution, then they don't have an institution anymore. Go home. There's no need for Washington, D.C., because the only thing that makes America America is that Constitution. And if our public officials that are responsible for preserving it don't have the courage or the honor or the fortitude to do their job and preserve it, then by failing to preserve it, they will have ceded their power back to the states, and the states will have reclaimed the power that was delegated through the Constitution.
Obviously, you're litigating this. Are you utilizing a handful of cases that are proceeding through the federal courts and state courts, or just federal courts?
So we're already through. We're already through. I already brought a case up through the court. So a number of years ago, this was back in 2019, I think. I filed it on April 10th, 2019, United States District Court of the Eastern District of Washington. And between April 10th and September 2019, I got more than 4,000 people to petition the exact same writ of habeas corpus that we brought up. We brought it through the district court, through the circuit court. Circuit court acknowledged the existence of what's called a jurisdictional error, which means that the district court exceeded the power authority statutorily conferred upon it by the Constitution when they made a ruling in a case in which the state was named a party. And anytime that you have a jurisdictional error, there's no time limits on it. There's no time bar. You can bring that case back at any point in time to resolve, at a minimum, the error that was created by the court when they took action in a case that they didn't have jurisdiction to be able to take action in. That's already been acknowledged. The circuit court's already acknowledged it. I can bring the case back at any point, but I don't want to do it early. I want to make sure that we go at the right time, when we have the right amount of momentum, and that court can't ignore it anymore. So, I can sit on this case for 50 years or 2 weeks or whatever. Right. I could bring that back. And the good news is that when you have a jurisdictional error, the court that originally had jurisdiction is the court that you bring it to. So if the Supreme Court of the United States had jurisdiction in that, and the district court exceeded the power authority statutorily conferred upon it and made a ruling in a case that only the Supreme Court had jurisdiction in, then that means that I can always and forever bring it to the court that had original jurisdiction, and at a minimum, that court has to resolve the jurisdictional error. In other words, the Supreme Court of the United States, which had jurisdiction acknowledged by a circuit court, the Supreme Court that had jurisdiction will, at a minimum, have to reverse and remand the judgment and send it back to district court, which is what they would typically do to avoid having to actually make the decision. But we put into place a few things in the remand order that will prevent them from being able to do that. But my point is that yes, so we got more than 4,000 other people to petition just in the state of Washington alone. But what I needed to do now was I needed to go around the country, raise awareness on the issue, start bringing together all of the other states that do this, start preparing for and joining those states into the litigation, because I personally can't sue, for instance, the state of Texas. I'm not from Texas. The 11th Amendment would bar me from being able to sue the state of Texas. I can finish the suit against the state of Washington, but I don't want to just beat Washington when all these other states need help. So what we've done here is that I've identified people within all these states that have been charged improperly by way of information, not by indictment. I've collected criminal affidavits on behalf of them or from them personally, and then we've taken them and served them on first the attorney generals of the states. So like Texas, I went down there and I personally took an affidavit signed by victims within the state who have been charged by information, not by indictment, in violation of the Constitution. And I took them to your attorney general, and I served them on an assistant attorney general there, and basically just said, listen, your prosecuting attorneys, because the attorney general is in charge of all the law enforcement. That's the highest law enforcement officer in the state. He's in charge of all the prosecutors. So if the prosecutors are acting unconstitutionally in violation of the United States Constitution because they're relying upon an inferior state statute, then by going to their boss and saying, hey, man, please correct the unlawful acts, the criminal acts of your agents. But if you don't, then you are permitting it to continue, And so that's what I did. I first went to the attorney generals, served all of them in 47 states. Then when the attorney generals failed to resolve this, then I went back and I served the state Supreme Courts, because they're in charge of all the judges. If the judges are conspiring with the prosecutors to deprive of rights because the judge is making a decision to hold someone over for this offense without an indictment by a grand jury, now we can go to the highest judicial officer and say, okay, please correct the unlawful acts of all of your agents. But if you don't, then you are permitting it to continue and you're now implicated in it. We did the same thing. They failed to take action. So then we needed to bring in the third branch of government that really has nothing to do with, with the conspiracy. Because if you think about it, the state of Texas created a law that permits their prosecuting attorneys to abridge their obligations in the Constitution, right? That's pretty simple. The state prosecutors are then relying upon that inferior state law to go out and to charge people improperly in violation of the Constitution, abridging their obligations that they have codified in the Constitution, and they're bringing that incorrect charging instrument to a judge. Well, they just committed the crime of deprivation of rights under color of law. There's no denying that. Title 18 USC subsection 242. And so then when they bring it to a judge and they say to the judge, I'd like you to hold this person over, that judge has a duty and responsibility to make sure that he doesn't exceed the power authority statutorily conferred upon him. If he chooses to hold someone over for that infamous crime without an indictment by a grand jury because the prosecutor brought the information, not the indictment, that judge has a duty to say, no, I can't do that. I can't exercise my power because I would be violating the Constitution. So when they fail to uphold the Constitution, willfully or negligently, it doesn't matter, because any breach of constitutional obligation, there's no right to self-defense for public officials. So the moment that judge holds someone over, well, he's now depriving him of rights under color of law, but he's also establishing a conspiracy by and between himself and the prosecuting attorney, and that is Title 18 USC subsection 241, conspiracy to deprive of rights. Mm-hmm. Then when that judge signs that order, right, after depriving of rights under color of law and establishing the conspiracy, and then hands it to a sheriff's deputy and says, please go out and execute this warrant, that sheriff can't go out and execute that warrant without depriving of rights under color of law also, right? And being a member of the conspiracy also. Willfully or negligently, it doesn't matter. Sheriff, you can't go out and execute a warrant that derives from an unconstitutional act and have that arrest be constitutional, which means that you yourself are engaged in that criminal conspiracy. You're a member of it. And absolutely. Unfortunately, the moment that you arrest someone without lawful authority to perform an arrest and you put them into a jail against their will and you hold them there under ransom in the form of bail, you just committed the crime of kidnapping. Title 18, subsection 1201, right? And so this is a situation. We have a conspiracy by and between the executive branch and the judicial branch to undermine the laws of the United States. And when I go to to the legislative branch, like the Senator Cruz, who I've talked with his legislative director and informed his legislative director that this is happening, his legislative director said to me, yeah, but that's a state issue. We don't get involved in that. We abstain from that because that's a state issue, not a federal issue. I'm like, no, it's not. That's a federal right being deprived by a state. That's a federal issue, not a state issue. Yeah, we don't get involved. We abstain. We don't get involved. So, the narrative that I get from the legislative branch consistently, whether it's representatives, senators, whoever, they say, oh, that's someone else's problem, not ours, right? We don't want to get involved because that's a big deal. 700,000 people currently in prison in violation of the Constitution of the United States of America by a conspiracy to undermine the laws of the United States by and between the judicial branch and the executive branch. That's a big deal, big enough that the legislative branch wants to stand back and say, well, we just want to ignore this and not be involved in this. So I had to find a way to remove their ability to abstain, right? How do we make the legislative branch get involved in this and address this when they're not a part of the criminal conspiracy technically, right? Technically. Well, we did that through what's called an emolument violation. You see, you can never pay someone to commit a crime. You can never pay someone to break the Constitution. That's called an emolument violation, right? An emolument violation. So if you pay someone to breach their constitutional obligations, that would be a crime in and of itself. Mm-hmm. So when you go out to these cities, right, if it's the police officers that are performing arrests and charging by information because the police don't know any better, that's what they're taught to do in their little police academy, rely upon the state statute that says you can do this and don't question anything else, and that's just the way it's done. Well, who pays for the police to do their work? City council, right? City council pays for the police to do their job. Well, who pays for the sheriff to go out and execute warrants? Well, that'd be the county commissioners, right? Yep. Who pays for the jail? Well, that would also be the county commissioners because it's a county jail. So what we're doing now is that the legislative branch pays for the people, the public officials, to do their work. Budgets originate from the legislative branch. So legislators, senators, congressmen, city council members, if you want to stand back and pretend like nothing's happening, ignore what's really going on and blame them for the issue, well, we're going to go ahead and come into your public meeting, have a public hearing to where Jessica and I, as well as 100 other people across the country, are going to say to you, this is what the Constitution says, this is what the police are doing, and you guys are paying them to do it. Therefore, you're responsible for these, because if you didn't pay them, they wouldn't commit any crimes at all, right? Hell, nobody's going to do anything if you don't pay them to do it. Right. So what we're doing now is we're putting city councils on notice, county commissioners on notice. We're going in, and what Jessica is doing is she's reading a 2-page script, right? 2 pages that I prepared, and it basically says, Constitution of the United States is the overarching requirements. No denying that. Constitution Clause 1 of Amendment 5 says this, state of whatever does something different. An emolument violation is you pay someone to break the law. Therefore, you guys are paying for these crimes to be committed, and we are here to provide notice to you that you can no longer do this. And if you do, criminal sanctions can come from that. And now we put the burden onto the legislative branch to say, do you want to be a part of this? You don't have to be, right? But now you've been put on notice. Now, if you continue to pay, now you are knowingly and willingly committing that crime. And you're a part of the criminal conspiracy because you're paying for people to deprive of rights under color of law. You're aware of the conspiracy and you're not mitigating it. So we had to find a way to bring the third branch of government in to put some skin in the game and to say, are you guys going to do something about this? Because clearly the Supreme Court isn't, and nor is the Attorney General. So maybe you guys will. Maybe not. But what I can say is that we're getting some good and receptive responses from the city councils, the mayors in a number of different places. They are saying to us, how could this happen? And what do we need to do to fix this?
I bet you'd like to sit down with the vice president of the Fraternal Order of Police Officers, huh?
The truth is that my degree is in substantive law. It's not adjective law. I have a master's in substantive law, which means I have a degree in law enforcement. I speak law enforcement. When I talk to law enforcement, they know what I'm saying. They understand it. It makes sense to them. I don't speak attorney's language. That's why attorneys absolutely hate it. That's why I'm the opposite of an attorney, is because I deal with the enforcement of the law. I do what a prosecutor should be doing but a prosecutor should never be an attorney, right? Attorneys are administrative officers of the court. They follow administrative law. They should not have anything to do with law enforcement. Law enforcement is substantive law, not administrative law. So I have a degree that a prosecutor should have, right? And law enforcement should never be following attorneys, such as with the FBI right now. Cash Jackson, he's an attorney. He's not law enforcement, right? And so when law enforcement, who's part of the executive branch, right, they're there to enforce the law. When they fail to recognize the fact that you are following judicial branch because an attorney is put into place to lead you, well, now you have consolidation of law enforcement into the hands of the judiciary, and that's not the way it was supposed to be. When I go and I speak to an attorney general, for instance, or an investigator for attorney general, such as I did in Rhode Island, and I inform them of this, and they say, "Well, I'm going to have to go and get information from my attorney." Fuck your attorney. This has nothing to do with your attorney. This has to do with your obligations in law enforcement. That's what, so if you're going to go to an exec or a member of the administrative branch, the judicial branch, in order to find out how you're supposed to act when you're a member of the executive branch, then I'm going to say that the administrative branch, the judicial branch, is able to control everything at that point. And there lies what we had, right?
Yeah.
Law enforcement should not be following them. But yeah, I mean, and we do get a lot of reception, good reception, positive reception from law enforcement. There's a lot of law enforcement that sit down after we're done and they ask me questions. And often, typically, the question is, am I going to be in trouble if you win this case? I'm like, well, I can say that today, what you're doing is a crime. It is illegal. And you can probably mitigate that according to law, but that's a decision you're gonna have to make. But that's the typical question that I get. I did have a couple sheriffs. One sheriff in particular, he met with me when we were traveling across the country, and he took his patch, his badge off his uniform, and gave it to me, and said, "I support what you're doing. You're doing the right thing."
Wow.
The problem is that we're not getting them to step out into the public and support this publicly just yet. But I'm telling you, Floyd, we're about to have that. There are a number of places where there are people teetering on the edge of deciding, am I going to support this, or am I going to pretend like nothing's happening and risk my life as a result of it?
If you and Jessica or whomever make it to Houston, let me know, and I will set up a meeting with you and whoever you bring or whoever you send, with Ray Hunt. You don't know who Ray Hunt is. He's the executive director, former past president of the Houston Policemen Patrolmen's Union.
Okay.
The president came after him is now the vice president of the Fraternal Order of Police Officers nationwide. Yeah. He's the one who went and endorsed Trump in Florida when he was running.
Yeah.
So if you want to meet with those two gentlemen, and I'm sure they can reach out to the constable's office, the Houston Independent School Police, as well as the sheriff's department, and do a little presentation. I'm sure, I can make that happen for you.
Okay. Yeah, absolutely. So we will be back to Houston again. We're about to start another loop around the country. We're going to continue to do this until we raised enough noise, until we brought enough attention to the issue that the court agrees to hear it. So what we're doing is, I've traveled back and forth, coast to coast across this country 24 times in probably the last 28 months. And I just keep on circling the country. And as we circle the country, we have different things that we do, like serving the attorney generals or serving the Supreme Courts, or right now serving city council, county commissioners. The last loop, I think that the last time we talked, we were getting ready to travel the country, and we did rallies and seminars, education opportunities, where we were building the affidavits and the 500,000 criminal affidavits that we did. So that's what I do. I mean, we travel around the country to try to inform people of these issues and make them aware of it, so that we can raise enough noise to where the court can no longer ignore it. Because again, the court's going to ignore this as long as the people are not aware of the issue, right? But once the people are made aware, then there comes a point in time when the court can't ignore it anymore, and then we get heard. And so that's what we're doing. And but we will be back in Houston. So we're planning another loop right now to continue to serve. We're asking people that want to help out that we do have a two-page script to read, which is what Jessica reads. Right, that's what she does. She takes the first 3 minutes in a public hearing with City Council, County Commissioner, and she reads that script, and then she provides the notice. The script this is to read and the notice to provide, those can both be downloaded from justicewithoutlimits.org. That's justicewithoutlimits.org. And you can download that. And then what you would do is you would, look up your local city council and you'd find out when the next meeting is. And in that meeting, there will be a period that will be dedicated to what's called public comments, right? And during a public comment period, you can go in and you can actually, provide a comment, right, to them. And what's amazing and beautiful about the public comment is that they can't even comment back. So right now we are controlling the narrative, right? We're controlling the narrative because government can't respond to things that we're saying because one, if they did, it would bring attention to the issue. And two, they can't because the law says that anytime you have a public comment on a non-agenda item, you can't respond. The council can't do it. So we're asking for people to come and help do that because I'm personally going out and I'm personally doing this because I believe in it. I believe that this is going to work. I believe in the work that I'm doing. No one would be out doing things I'm doing if they didn't believe in it. But in order to lead, I believe that a leader needs to get out and actually lead. And so that's what I'm trying to do here is I'm trying to show people that you can do this. You can go to your public officials. You can stand and tell them that they're committing crimes. And I want people to not be scared to correct these injustices. So, but unfortunately, I can't serve, and Jessica and we can't serve everywhere. We need a lot of help to do this, and that help needs to happen as quickly as possible because we need this. We need this done as quickly as we can. Yeah, yeah.
Is this it? It's a iDrive.
Yeah. So in here, we have a couple of different affidavits. That's what there are. The instructions are there. Then you have the familial unit affidavits. So this is for the affidavits here. It's not the service. This is where you would go if you wanted to download the affidavits that we would need. So basically what I've done is the indictment affidavit, that number 5 right there. If you were to click on it, if you're to click on that, it will open up a 2-page criminal affidavit. And what we're trying to do here is we're trying to get everybody in the same procedural situation so that when I go to the Supreme Court and I argue this issue and I say, okay, the states were supposed to have an indictment and they didn't, then all of these people that deliver us an affidavit would be in the same procedural situation. Therefore, they would immediately receive relief. So if one petitioner can overcome the procedural situation, all petitioners can. And so I'm preparing to argue this. And so we're asking for people to send in affidavits to us. If you've been charged with or convicted of a crime by the United States justice system or system subjected to the jurisdiction thereof, which would be a state justice system, you can fill out that affidavit. It's 22 pieces of information. We don't want any more information. We want every one of these to be exactly the same. So it's very, very simple, month and year of your charge, month and year of your trial, your name and so on, and you sign it. And then you would send that into a post office box that we have in North Carolina. Back there, number 1 was an instruction sheet. Inside of the instruction sheet, it has an address to the North Carolina post office box. That's where we're receiving all of them. Today, we've got close to 2 million of these, and we're going to continue to collect these up until the time that the court agrees to hear the case. So, this is the way that the people can get behind me by saying, yes, this happened to me in the same way. And then in doing so, I would be able to litigate these all at once. Here's the nationwide notice. So that very first one there, notice to provide, that is a 4-page notice that you would provide to the city clerk after you read the script, which is what Jessica has here is some city councils only allow you to speak for 1 minute, such as Houston. We had to get this all out in 1 minute in Houston. It was very difficult and tough, but you can see the video out on TikTok and YouTube and Facebook. So we each had 1 minute to speak and to get all of our information out. But that's what these scripts are. So there's a 1 minute script, there's a 2 minute script, and a 3 minute script. The majority of the city councils and county commissioners are allowed to speak for 3 minutes. Majority of them allow 3 minutes. So that would be the one that you would download, the one in the middle there. But that is what you would read, and you would just take that in, and you would take that in, you would read the script, and then you, at the end, it says, I have a notice I'd like to provide. And then you can't hand this notice right here off to the city clerk, and that's it. And that puts these city council members, these public officials, on notice that you are paying people to commit a crime, and that you need to decide, am I going to follow a judge-made ruling or the Constitution of the United States? Because I'm going to tell you right now, I'm going to win this case. The Constitution is the supreme law of the land. Nothing can change it except for an explicit and authentic act of people. And so the Supreme Court of the United States never had the authority to do it. So by bringing this up, remember, ignorance of the law is no justification for having broken it, right? As the public official, your fidelity is bound with and to the Constitution of the United States of America. It doesn't matter if someone tells you to go and commit a crime. If you choose to go and commit that crime, you are held culpable for it. Remember, servants of tyrants cannot take refuge in the excuse that they are just following orders. So they have to decide. Every single one of them is going to have to decide, am I going to follow the Constitution that requires it, or am I going to follow the Supreme Court ruling that says I don't have to do it? And I'm going to tell you right now, it's going to be a very, very bad decision, dangerous decision, if they choose to follow a judge-made ruling, which is not law. It's going to be a very bad decision.
All right, you have 700,000 roughly people. You're not representing them, but they are affected by your pursuit of this issue or issues.
Yeah.
So are you asking for a remedy, or, would everybody that has gone through, let's just say for myself, I spent 14 years, 2 months, lost everything I owned, ruined my relationship with my daughter. I mean, I can go on and on and on. What's the recourse for that? Or do I just say, hey, you know what? I'm glad that I don't even have that conviction or deal with that anymore. Is that the demarcation line for people, or some people really want their pound of flesh?
So all that I can say is that, once again, Duralex said Lex. It may be hard, but it's the law, right? We will not compromise on the law. Constitution of the United States requires it. You didn't do it. So I am not saying that any of these people are innocent. I don't know, right? That's not up to me. That was up to the state, and the state needed to determine their innocence or guilt. But what I can say is that none of these people are guilty, because guilt is a process, and you must follow that process. And if you don't, there cannot be guilt. Even Scripture says that. 2 Thessalonians says that where there's unlawfulness, there cannot be guilt. So what I can say is that I'm not fighting for anyone's innocence, but what I am fighting for is their guilt. These people are not guilty of anything, because the state failed to follow the duly prescribed procedures and processes codified and protected in order to preserve the individual liberties of the people. It doesn't matter why you did it, state. It doesn't matter who told you can do it, state, because the object of which your fidelity is bound is with and to the Constitution of the United States of America, and it says that you must have it, and you didn't do it. So at the end of the day, in order to fix the problem, we first got to start talking about the fact that there is a problem. Today, the Supreme Court is ignoring this. They're refusing to acknowledge it. I've submitted this. I submitted the writ to them on September 29th of 2023. They abstained, refused to docket it because they're so scared of this. And so, going back to the rules, and following the rules, I made a decision back on September 29th of 2023 after I submitted the writ that why am I going to go to criminals and ask them to stop committing crimes? I know what they are. If I play with a scorpion that stings me, I'm not going to blame the scorpion for stinging me, right? I already knew what it was. But likewise, why am I going to continue to play by the rules of a system that doesn't adhere to its own rules? So, ultimately the decision is going to come from the court, but the battle is fought in the opinion of the public. You see, it's not up to me to decide what should be done. It's up to me to hold criminals accountable for the crimes they commit, because I'm an expert in substantive law. I'm an expert in law enforcement. And criminals must be held accountable for the crimes that they committed. I don't know what the remedy should be, but no prosecutor in the world or at least here in America, should ever be attached to the outcome. It's up to me to present the evidence in the fairest and most neutral manner that is in the best light and truth, so we can come to terms with, with justice. And the justice has to be left up to the people of the United States. It's up to the people to decide what they want to do about this issue. It's not up to me.
Right.
So if the people deserve remedy, if they deserve relief, at the end of the day, what I can say is that the evidence that I have shows that right now today there isn't a single conviction that this system has obtained that is consistent with the Constitution.
Lawful.
Because when the highest court in the land, when the Supreme Court of the United States introduces fraud into the system in 1884 and directs every single court in the country that you can follow this judge-made ruling in violation of the Constitution by introducing that fraud that permeated every single court in the entire country, that are now still operating under that fraud. Remember, fraud vitiates any judgment, any action. Until that fraud is removed, nothing that any court does is valid. So the Supreme Court of the United States really needs to fix this, because nothing that any court within the purview of the Supreme Court is operating constitutionally because of the court's own fraudulent direction. When the highest court in the land directs every single court within its purview that you don't have to follow the Constitution of the United States, that was fraud introduced in 1884. And until that fraud is removed, it vitiates any criminal action that's in place, which means that I don't know what we should do with these people, but we better start talking about it as a nation, because none of them are being held lawfully consistent with the Constitution in an enslaved state within any one of these states. Not one of them, not a single one. So we can talk about 700,000 criminals, right, that aren't criminal because there's no judgment. We can talk about the direct facial constitutional violation that exists for 700,000 prisoners, so we can talk about a much bigger issue, and that is let's get rid of this fraud that was introduced, and let's put the Constitution of the United States of America back in its rightful place, the foundation, and let's get judges out of the business of creating what the people are rightfully obligated to create themselves.
You said that. Thank you for hanging around after the show. I want to present to you Tailor-Made Trust, featuring Ann LaFleur's Trust Series, available at tailormadetrust.com, as well as the fearlessfloydshow.com store. Here are a handful of the available trusts that can be built, custom tailored to your needs and desires. 25 different trusts, plus the DNA trust addendum. And as always, Ann LaFleur's classic trusts and ancillary classes, and also Ann's books on trust and specialty trust, which I also co-authored. If you'd like to get a class, a book, or have a trust custom built for you, always available at the fearlessfloydshow.com store. And I'll see you in the next show. Thank you for watching, and have an awesome day.